Representative of Kuwait, His Excellency Mr. Ali Ahmad Brahim Al-Dafriri. You have the floor, Excellency.
Bismillah ar-Rahman ar-Rahim. Mr. President, honorable members of the court, it is a great honor to appear before you as the agent of the state of Kuwait in these proceedings. Kuwait deeply appreciates the extraordinary effort taken by the court to allow this hearing to proceed smoothly in light of the great number of participants. The current advisory proceedings are of extreme importance to the Palestinian people, Kuwait, the international legal order, and the international community as a whole. Kuwait has always advocated that peace fosters the observance of law and vice versa. Adherence to the United Nations Charter is an indispensable prerequisite for the definitive establishment of international peace. Indeed, peaceful relations are founded on accepted rules, and as such, peaceful relations among states are based on the provisions of the United Nations Charter. These include, notably, the principle of non-use of force and the peaceful settlement of disputes. These rules apply to all states. Respect for these fundamental rules contribute to the consolidation of international peace. Regrettably, the above-mentioned foundational rules have not been upheld in the case of Palestine. The conflict between the Palestinian and Israel, hereafter referred to as the occupying power, is an illegal occupation conflict involving, on one side, an occupying power equipped with all military means, and the other side, an occupied nation without defensive capabilities, facing daily expulsion, human rights violation, and all sufferings associated with any occupation situation. Over the past decades, the situation between the Palestinians and the occupying power has been extremely tense, resulting in a serious human rights law and humanitarian law violation committed by the latter. Various intergovernmental and non-governmental organizations have documented these violations by publishing comprehensive reports. This climate of violence compromises any possibility of reasonably discussing the issue at stake. This is further exacerbated by the recent development in Gaza. The occupying power has waged an illegitimate war on the Palestinians in Gaza, characterized by numerous international law violations. The ongoing flagrant violations have been highlighted in a series of statements issued, among others, by the UN Secretary General, the UN High Commissioner for Human Rights, and the special procedures of the UN Human Rights Council. The unprecedented violence in Gaza is a result of 57 years of illegal occupation of the Palestinian territories, and it must stop. The late Emir of the State of Kuwait, His Highness Sheikh Sabah Al-Ahmed Al-Jaber Sabah, Mr. President, summarized the situation in 2018 by stating, we asked the whole world by stating, quote, Mr. President. Quote, why do we ignore and do not implement Security Council resolutions? Why? We ask the whole world, why the Palestinian people plight continues? Why the international community incapable of resolving this cause? Why does the victims continue to be portrayed Why does the victim continue to be portrayed as a killer according to Israel's norms? Why does Israel always escape punishment? Why have all these souls been lost amid absence of world conscience? Unquote. Sorry, Mr. President.
Sorry.
Mr. President, distinguished members of the court, it is in this context that Kuwait appears for the first time before the court, following the adoption by the UN General Assembly of resolutions 77247, requesting the court to deliver an advisory opinion on two legal questions. The first question asks the court to evaluate the illegality of the occupying power's specific policies and actions within its occupation of the Palestinian territories, while seeking the court's determination of the corresponding legal ramification. The second question addresses the core issue. Has the occupation become illegal? Kuwait will demonstrate the illegality of this occupation, underscoring the necessity of its cessation. Mr. President, honorable members of the court, my distinguished colleagues will now address these issues in greater depth. Second, first, His Excellency, Ambassador Tariq Al-Bannai, permanent representative of Kuwait to the UN, will address why the court does have jurisdiction to deliver the advisory opinion requested by the UN General Assembly. He will also highlight certain legal practices and policies of the occupying power. Second, Her Excellency Tahani Al-Nasser, Assistant Foreign Minister for Legal Affairs of Kuwait, will start by enumerating the grounds proving the illegality of the occupation of the Palestinian territories, hereafter referred to as the OPT. She will then focus on the legal consequences arising from the breaches of those fundamental rules. And finally, she will provide the court with a certain concluding remarks. Thank you, Mr. President, honorable members of the court, for the privilege of appearing before you. I now kindly ask Mr. President to invite Ambassador Al-Bannai to address the court.
I thank His Excellency, Mr. Al-Dafiri. I now give the floor to His Excellency, Mr. Tariq Al-Bannai. You have the floor, Excellency.
Mr. President, honorable members of the court, it is a tremendous honor and privilege to appear before you on behalf of the State of Kuwait. 20 years have passed since the seminal Wall Advisory Opinion. Today, in these current proceedings, the question of the illegality of the occupation of the Palestinian territory is directly before the court. With your permission, I turn now to my first topic, focusing on whether the court has jurisdiction to render the advisory opinion requested. In Kuwait's view, the answer is a categorical yes. Indeed, the majority of submissions in these proceedings argue in favor of the court's jurisdiction. Article 65 of the Statute of the Court provides that the court may render an advisory opinion, and I quote, on any legal question at the request of any organ or institution authorized by the Charter of the United Nations or in accordance with its provisions to request such an opinion, unquote. In turn, Article 96 of the UN Charter, quote, the General Assembly or the Security Council may request the International Court of Justice for an advisory opinion on any legal question, unquote. In practice, it is primarily the General Assembly that has most frequently utilized this procedure to date. After all, when the General Assembly decides to request the court to deliver an advisory opinion, this means that the request reflects an important concern of the international community, seeking a legal answer. The court itself observed that the General Assembly, within the scope of its peacekeeping responsibilities, has a broader perspective than that of the Security Council, as it also considers humanitarian, social, and economic aspects. An attentive look at the court's jurisprudence points to the fact that, quote, only compelling reasons may lead the court to refuse its opinion in response to a request falling within its jurisdiction, unquote. Although the court has the discretionary power to refuse to respond to a request for an advisory opinion for reasons of judicial propriety, it has not availed itself of this option thus far. In the present case, it is incontestable that the questions included in the relevant General Assembly resolution are clearly specific questions of legal character. Any attempt to qualify them as non-specific or non-legal should fail. It is worth noting that the court, in the Wall advisory opinion, rejected similar attempts. In essence, in the Wall advisory opinion, the central issue revolved around the construction of the wall and its impact on the right to self-determination of the Palestinian people. 20 years later, the context has broadened substantially. The court is now tasked with determining the legal status of the ongoing occupation of the occupied Palestinian territory since 1967, given its persistence for over 57 years. Prior to addressing the next topic, I feel compelled to briefly refer to an argument certain states have made, fallaciously alleging that the issuance of an advisory opinion might undermine ongoing negotiations and peace processes. This argument, Mr. President, honorable members of the court, is groundless and without merit. Kuwait has always underscored the importance of resuming peace negotiations with a view of reaching a just and comprehensive peace based on the terms of reference of the peace process, the resolutions of the Security Council, and the Arab Peace Initiative. However, the relevant UN resolutions and the Wall advisory opinion make clear that any negotiations that take place must have as their objective the achievement of a just and lasting peace in accordance with international law. The court has an important role to play in this regard by stating what the applicable rules of international law are, including the rights and obligations of the relevant parties, all states and the United Nations. This is exactly the purpose of the UN General Assembly resolution requesting the court to deliver an advisory opinion. By doing so, the court may in fact help revive negotiations and inspire a return to a peace process premised on international law. After all, the court's advisory opinions shed light on complicated legal issues, appeasing tensions, uncertainties, and potential disputes. Mr. President, honorable members of the court, I will now address our second topic, providing you with examples of the occupying power's unlawful and egregious policies and practices in the OPT. In the interest of time, I will limit my presentation to 3 policies, which demonstrate the true nature of the illegal occupation. The first is forced displacement. The second relates to the illegal settlements on and the annexation of the Palestinian territory. And the third is discrimination at a scale and nature that amounts to apartheid. The remaining issues were discussed thoroughly in the written submission of Kuwait. In the 1948 Nakba, 750,000 Palestinians were forcibly displaced, and since then, millions more. The situation has deteriorated exponentially since the illegal occupation started in 1967. The occupying power has engaged in a forced displacement campaign against the Palestinians by demolishing their homes and confiscating their lands. Forced displacement violates international law. The occupying power is under the obligation to ensure that its operations in the OPT comply with the Fourth Geneva Convention of 1949, relative to the protection of civilians, persons in time of war, to which it is a party. Article 49 of this convention clearly prohibits, quote, forcible transfers, individual or mass, regardless of their motive, unquote, which includes forced displacements, as well as expulsions from the OPT. Furthermore, Article 53 of the same instrument prohibits the destruction of property. Finally, under Article 147, illegal transfers, destruction, and appropriation of property carried out on a large scale is prohibited. As Kuwait explained in its written submission, the occupying power has also committed other grave violations of international law, including the policy of settling parts of its population in the OPT. This unlawful policy has and continues to be deplorably promoted by the successive governments of the occupying power. Since 1967, the occupying power has embarked on an intensive campaign of colonization. Some settlements consisted of just a few prefabricated houses, while others expanded to become fully fledged small towns. In early 2023, there were around 730,000 Israeli settlers and over 280 Israeli settlements in the occupied West Bank, including 230,000 settlers in East Jerusalem. These settlements are sustained by a network of military checkpoints and restricted zones, as well as Jewish-only roads and highways, all of which limit gravely the lives and livelihoods of Palestinians and violate their fundamental human rights. Both the construction of settlements and the transfer of settlers to the West Bank and Gaza are grave violations of international law. In particular, Article 49 of the Fourth Geneva Convention, which states that, I quote, the occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies, unquote. It is also noteworthy, Mr. President, that settlers in the OPT are not governed by the same laws that apply to the indigenous inhabitants of the territory. Jewish settlers are provided with special rights, facilities, and subsidies that are denied to the indigenous Palestinian population. The occupying power's policy not only supports the existing settlers, but also incentivizes new settlers. The discriminatory policies and practice also violate the sovereignty of Palestinians over their natural resources, allowing the settlers and foreign companies to exploit the water and agricultural products of the occupied land without any benefit to the occupied population. It is widely recognized that the occupying power has codified its discriminatory policies and practices against Palestinians in its legislation. Specifically, it grants rights to Israeli Jews and systematically discriminates against Palestinians. For instance, the Land Acquisition Law of 1953 facilitates the alienation of confiscated Palestinian land for the benefit of various institutions of the occupying power. Quasi-public organizations, such as the Jewish Agency, engage in material discrimination, in particular through the allocation of confiscated Palestinian land to Israeli Jews. Mr. President, honorable members of the court, Thank you for your kind attention, and may I kindly ask that you invite Her Excellency Tahani Al Nasser to the podium.
I thank His Excellency Mr. Al-Banai, and now I give the floor to Her Excellency Mrs. Tahani Al Nasser. You have the floor, Excellency.
Thank you. Mr. President, distinguished members of the Court, it's a great honor and a privilege to appear before you on behalf of Kuwait. In the written submissions, the great majority of states participating in these proceedings, along with the 3 intergovernmental organizations, concluded that the occupation of the OPT is illegal. Kuwait firmly agrees with this view in its written submission. Kuwait identified several reasons proving the illegality of this occupation. I will provide a brief overview of these reasons for the Court. The occupation violates a series of jus cogens norms. First, the obligation to respect the right to self-determination of the Palestinian people. The right of people to self-determination is a right clearly recognized in international law as evidenced by several instruments and as submitted by 35 states and international organizations participating in these proceedings. This is articulated in Article 1.2 of the UN Charter, which define the purposes of the United Nations, including, I quote, to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples, and to take other appropriate measures to strengthen a universal peace. Unquote. The same obligations are expressed in Article 1 of the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. Second, Kuwait joined the participants in these proceedings who have concluded in their written submission that the ongoing military occupation of the OPT is illegal because it violates the jus cogens prohibition on the use of force. Third, the occupying power, by confiscating and annexing parts of the OPT, violates the prohibition on the acquisition of territory by force. This was underscored by 38 participants in the written proceedings. This fundamental norm was incorporated into Security Council Resolution 242 of 1967 and reaffirmed in Security Council Resolution 338 of 1973. Accordingly, the occupying power does not have the right to claim sovereignty over the OPT occupied since 1967. Fourth, the occupation is illegal because it obviously violates the law of military occupation. For instance, the occupation of the OPT is not of minimal duration. Facts clearly demonstrate that it is intended to be prolonged and ultimately permanent. A permanent occupation constitutes a serious violation of international law based on the verifiable evidence available to us. It's indisputable that this is precisely what is happening in the OPT. This prolonged occupation and identified violation of the Palestinians' right to self-determination renders the occupation illegal. Moreover, the conduct of the occupying power in the OPT violates the rules of international humanitarian law. In the World Advisory opinion, the Court stated that, quote, the Fourth Geneva Convention is applicable in the occupied Palestinian territories, unquote. The Court also determined that the Hague regulations are reflective of customary international law and thus applicable to the conduct of the occupying power in the OPT. Far from complying with the law of occupation, the actions of the occupying power disregard international law. These actions include, inter alia, the establishment of settlements in the OPT, confiscation of Palestinian public and private property, and its failure to protect Palestinians from violence caused by state actors and private parties, including, inter alia, armed illegal settlers. Finally, the occupation violates the jus cogens prohibition of apartheid. 21 participants in these proceedings supported this in their written submissions. while 14 maintained that the situation of apartheid qualifies the occupation as illegal under international law. The prohibition of apartheid is evidenced in various sources of international law. The occupying power is bound by the 1965 Convention on the Elimination of All Forms of Racial Discrimination, to which it is a party. Furthermore, it shall abide by the prohibition of apartheid as enshrined in 1973 International Convention on the Suppression and the Punishment of the Crime of Apartheid, which codifies customary international law. Several voices and independence experts have warned that the occupation of the OPT amounts to a regime of apartheid. For instance, in March 2022, the Special Rapporteur on the situation of human rights in the Palestinian territories occupied since 1967, in his report reached a similar conclusion. Kuwait, respectively, suggested that the above violations cannot be reconciliated with the fundamental rules of international law. Hence, the occupation must be declared illegal in accordance with international law and the relevant UN Security Council resolution. It must stop. This will guarantee the right of the Palestinian people to be available state and along 1967 borders with East Jerusalem at its capital. Mr. President, members of the court, the legal analysis of the question involved in these advisory proceedings demonstrate that the occupation of the OPT is illegal, in contravention of the fundamental rules of international law. It is written submission, Kuwait did address the legal consequences arising from the occupying powers, numerous and long-standing violations of these rules. Please allow me to provide with a view d'ensemble. As indicated, the action of the occupying power and the occupation as a whole are plenarily incompatible with the rights of the Palestinian people and obligations of the occupying power under international law. Its breaches of these rights and obligations engage the occupying power's international responsibility. The occupying power must therefore take several measures. First, it must provide Palestinians with relief in accordance with the principles of customary international law on the responsibility of states for internationally wrongful acts. This must be achieved through the immediate cessation of its illegal occupation. Second, the occupying power must give assurance and guarantees of non-repetition of its international law violations. The occupying power shall commit itself to not repeating the same breaches in the future. Finally, the occupying power is under the obligation to make full reparation for the injury caused by its occupation and discriminatory policies and practices. As for all other states, they are all obliged to refrain from acknowledging the legality of the situation created by the illegal occupation and associated illegal policies and practices. They shall also abstain from offering support or assistance to sustain the circumstances stemming from the unlawful occupation and associated actions. Third, the state shall also contribute to safeguarding the Palestinian population against war crimes, genocide, and the crimes against humanity, and ensure that those responsible for crimes committed within the framework of illegal occupation are held accountable. In turn, the UN shall refrain from acknowledging the legality of the situation resulting from the illegal occupation and associated actions. The UN shall also refrain from offering support or assistance to prolong the situation and should instead cooperate to bring an end to the illegal occupation. Mr. President, honorable members of the court's advisory opinion is now more than ever necessary to put an end to the illegal occupation of the OPT. Kuwait has sought to concisely summarize the grounds for finding that the occupation is illegal as a whole, and submits that each ground of illegality shall form part of the court's dispositif. We are confident that the court will assess Kuwait's written submission and oral statement as an expression of its faith in justice, its support for the rule of law, and its desire for peace for all states in the region. Mr. President, honorable members of the court, this ends Kuwait's oral statement. Kindly allow me, on behalf of Kuwait's delegation, to thank the court for its kind attention, as well as the registry staff and the interpreter for all their support. Thank you very much.